In December of 2019, George Laine, a 65-year-old from Astoria, Oregon, drove over the center line on a rural two-lane road, hitting a family's vehicle head-on, injuring everyone and causing an 11-year-old boy's death. Witnesses driving behind Mr. Laine stated Laine swerved in the opposite lane and onto the right shoulder at least 10 times prior to the crash. The driver flashed their lights and honked multiple times, but that went ignored. The passenger took a video of Laine's driving that became a critical piece of evidence against him. Laine passed a breathalyzer at the scene, blowing 0. Unfortunately, the evidence clerk accidentally dropped Laine's blood samples and ran them over while working to mail them. Laine admitted to being at fault at the scene, also stating he was going through a rough divorce and he was headed home from a doctor's appointment when the accident occurred. He had been diagnosed with stress and anxiety, was prescribed medication, but had not taken any. In 2020, Laine settled a wrongful death lawsuit with Gavin's sister, who was also in the car, being awarded $300,000, which would become accessible when she turned 18. Court records indicate the vehicular homicide charge wasn't filed against Laine until September of 2022, 21 months after the collision. He pled not guilty on November 4th, 2022. He was found guilty, and George Robert Laine is now appealing his conviction, arguing that 1. The state presented insufficient evidence to convict him of vehicular homicide by driving in reckless manner, and 2. The prosecutor engaged in misconduct during closing arguments when he referred to the deceased boy's age when discussing recklessness, and that the damage to the vehicles was evidence of recklessness. Before we take a look, if you like this video, please take a moment to like and subscribe for a new video every week.
Aaron Orheim here on behalf of the appellant, George Laine. Mr. Laine also has some family members present in the courtroom today I'd like to acknowledge. This court should reverse because there is not sufficient evidence to support the jury's verdict that George operated a motor vehicle in a criminally reckless manner. He was not rash, heedless, and indifferent to the consequences of his actions. The state failed to prove this element beyond a reasonable doubt, which should have been dismissed and never sent to the jury. And the state doubled down on the lack of evidence by making improper argument to the jury in closing. The prosecutor hammered home the resultant harm of the accident, tragic death of a child and damage to the vehicles as evidence of reckless driving. And the prosecutor invited the jury to speculate without evidence that the sheer damage to the vehicles proved reckless driving, without any accident reconstruction or expert opinion in the record to support that. It is misconduct to ask the jury to return a verdict based on prejudice and facts not in the record, and this court should vacate the reckless driving conviction, or at the very least remand for a new trial free from prejudicial misconduct. Now, Your Honors, there's 3 ways that the state can prove a vehicular homicide. Driving under the influence of intoxicating liquor or drug, that is not the case here. Mr. Laine was completely sober, and all the evidence confirms that. The state can show that that driving, operating motor vehicle with disregard for the safety of others, or alternatively in a reckless manner. Driving in a reckless manner means driving rashly, heedlessly, indifferent to the consequences. It carries 5 times the punishment as driving with disregard for the safety of others, which is already a high bar beyond criminal negligence.
So there's testimony that he drove across the center line or off the road 10 times in a period of 5 minutes. Why isn't that at least some evidence that the jury could find is heedless?
The evidence in the record, Your Honor, is that it was between 10 to 15 minutes.
Well, it's light most favorable to the state,
yes.
Right? So that would be 10 minutes.
10 minutes, yes. And the most
or 10 times in 5 minutes.
It was my understanding is that the minutes is 10 to 15. The times is 5 to 10 or 6 to 10. So 10 minutes where he's driving down a rural road where passing is allowed, where it's a dotted line, Your Honor. There's no evidence he crossed a median. There's no evidence he crossed double yellow lines. He simply departed from his lane during those course, that long stretch down a rural road in dark, wet, unfavorable conditions to this sort of crash.
Counsel, was there evidence that he was passing a vehicle?
No, Your Honor. Other than the passenger in the vehicle that was struck said at the time that maybe he was passing another vehicle. But there is that evidence, Your Honor. But even in that, taking that evidence into account, the trailing witness who videotaped the incident said that they didn't think to call the police because it didn't seem like that big of a deal at the time. This is a rural, empty road. No one testified as to other cars being present. This is a far cry from the many cases that we cite in our briefing where reckless driving is found, where there's sashaying along I-5 in the opposite direction, eluding police, speeding while intoxicated. Yes, Your Honor.
Counsel, can the jury disregard that witness's opinion as to whether it was serious or not?
Well, I think it's evidence that's in. I would say no, Your Honor. It's the only evidence that we have. It's the only evidence that this court has to evaluate the conviction in this case, because there's nothing else the state put in the record as far as.
Now, to be sure, it is the jury's final determination to make whether this was reckless or not, right? So they don't have to. At least I can't speak for my panel mates, but the jury could disregard the opinion testimony of the person taking the video, the observer.
Well, I think
No?
he didn't think it was that big of a deal, and I would say, Your Honor, that the court also serves a gatekeeping function. We moved it, there was a motion at halftime to say that there's not sufficient evidence of driving rashly, heedlessly, indifferent to the consequences. And there's no authority that the state relies on that says this similar behavior can uphold a conviction. It shouldn't have gone to the jury in the first place, Your Honor, would be my point. And again, that's one element of, one part of the definition that, how was he rash? He was not rash. He was maintaining his speed. He was, there's no evidence he was speeding in this case. He wasn't racing. He wasn't driving wholly on the wrong side of the road. He tried to return to the right side of the road. That's
Now,
what the video
the video
showed.
does show, I believe it was 4 seconds, which in viewing the video, that's quite a long time to be completely in the opposite lane of travel. And isn't that indicative of some kind of mental state? I mean, if we've all been on country roads. I live in a county that's mostly rural, and we've all sort of coming across multiple turns. Although this was a bit of a straight road, but you can graze a line here or there. But this is actually, from the video, the gentleman, Mr. Laine, driving completely in the opposite lane for sustained periods. Is that conduct indicative of a different mens rea than simply coming over one tire length perhaps and then returning?
Yeah.
Isn't the whole of it indicative of a reckless mindset?
I understand the question, Your Honor. The whole of it includes other factors too, like him maintaining his sobriety, maintaining the operating, portion of his vehicle. And the reason, you talk about what's the mental state of him departing from the road. Well, he said, I'm undergoing mental anxiety, in my life, mental stressors. And he went to the doctor that day to try to treat that condition. So he was taking heed to treat, and no one told him he was unsafe to drive. There's no evidence of notice he had that he was unsafe to drive. So, I take the court's point, departing from the lane, he does depart from the lane, all the way over into the other lane. Approximately 6 to 10 times over 10 to 15 minutes. He makes it 5 miles without striking anybody or anything. He tries to correct himself. The only qualm I take with Your Honor's characterization of the record is that there was evidence he was in the opposite lane for a sustained portion of time. The video, like you said, was a matter of a couple seconds. He corrects himself. Was he peeking out to look around other cars? Was he thinking, as he testified, he's maybe seeing something in his peripheral vision that's maybe darting across in these dark, wet, dusk conditions on a rural road? All that can be taken into account, Your Honor, but the picture it paints is not one of criminal recklessness, conscious disregard, indifference to the consequences. He was very conscious of the consequences. He stayed at the scene. He cooperated fully. This is not speeding into, again, and there's no evidence of other vehicles around. So it's not, him going into the opposite lane and making other people depart from him or playing chicken with vehicles. That kind of conscious horseplay speeding, intoxication, those conscious, those hallmarks of reckless driving that case law tells us, State v. Lopez, that's that case, Your Honor, horseplay, speeding, intoxicants, those are the hallmarks of reckless driving. No Washington court has said inattentive driving alone is reckless.
Although
The level of-
I'm sorry, go ahead, Judge.
Go ahead, Judge Cruiser.
You characterize this as inattentive driving. That's your characterization. The jury is entitled to draw inferences. The jury did hear about a mental health crisis he was undergoing. It's notable that you talk about the absence of traffic in the other direction, and then when a car comes in the other direction, being driven by the Lahota family, he goes into that lane and hits that car. Couldn't the jury have also drawn an inference that even goes beyond the recklessness that they were asked to conclude? I mean, there's a tinge of maybe this was intentional, is there not?
No, the state specifically said that they've not argued intentionality.
Well, I know they didn't charge that, but what I'm telling you or asking you, what about the jury's ability to draw inferences about why your client may have been driving in this manner?
Well,
they're allowed to draw those inferences, are they not?
It's not just that they didn't charge it, Your Honor, as the state said. No one is accused, there's no evidence or accusation that,
Yes, I know what the state said. I'm talking about the jury heard the whole evidence and heard that this is a very unusual fact pattern where this person was seen driving in an extremely dangerous way. You're talking about, well, the dangerousness of it was due to inattentiveness. Perhaps the jury thought it was due to something else. But you don't deny that it's extremely dangerous to be driving entirely in an oncoming lane. You don't deny that, correct?
I deny that that evidence is driving in a reckless manner. I agree with the notion of your question. I will eat into a little rebuttal time though, because this plays into the second point that is just as important as the first, Your Honor, is that the state knew that the evidence of recklessness was lacking, and so they tried to get to evidence that was not in the record to prove recklessness. They said, look at the damage, the sheer damage to the vehicles. That's not just negligence, that's reckless driving, right? Well, that's calling the jury to appeal to return a verdict based on the resultant harm. Again, the jury can only draw the inferences from the record that is supported. Mr. Laine is entitled to a fair trial based solely on the evidence that's submitted at trial. And the prosecutor's appealing to the victim's tender age and damage about vehicles, which is irrelevant to prove his mens rea and mental state and actus reus before the incident. It shows how weak the case was for recklessness. It was prejudicial misconduct. It could not have been cured. I'll reserve the rest of my time. Thank the court.
Thank you, Mr. Orheim.
Good morning. My name is Craig Newman. I'm an attorney for the respondent, the state of Washington. I believe that there is plenty of evidence of recklessness. Just the sheer fact that he had to have been aware that he did not have the faculties to drive. And he was put on notice the first time he crossed the center line. And then it was reformed the second time he crossed the center line. At that point, he had a duty to pull over. But he just chose to go forward even though he couldn't maintain his own lane travel. That was reckless. It was a reckless choice on his part. And the result...
Why isn't that negligence? I mean, it was a mistake, clearly. He should have pulled over. He shouldn't have been crossing over the lane. But why isn't that just negligence or even gross negligence instead of reckless?
Because he's in a car. The most deadly object we have in our society. A car. And the result is the result. His behavior resulted in a head-on collision with another vehicle traveling at about a closing speed of 100 miles an hour. To continue driving that way on a two-lane road is reckless because a car is the deadliest object in our society. Now, as to the statement that the passenger believed it wasn't that big of a deal, the driver did. She made the statement, "I've never seen someone drive like," and then the video ends. And The reasonable inference is like this. I've never seen someone drive like this. And we've all seen people drive recklessly. I'm sure she's seen people drive recklessly. And apparently, her reaction was, this was the worst one. Now, all inferences, reasonable inferences, should be made in favor of the state. And when he talks about making reference to the damage to the vehicle, that this was prejudicial, mainly he's making the argument that there wasn't an expert reconstructionist. But all of these things that were said are common knowledge to people. The word head-on, collision, has common meaning among the citizens of this state. The amount of damage you cause in your car, cause with your car, indicates the amount of recklessness you were engaged in. A full head-on collision causing the entire front of the vehicle to collapse is evidence that you did a reckless thing. And it is free game for a prosecutor to point out things that were testified to, such as it was a head-on collision and there was extreme damage to the victim vehicle. Now, as to the 11-year-old boy, it was true. He was 11, and the defense attorney also mentioned it as well. It was only mentioned twice during the 2 closing arguments, and such things neither was objected to, and so they weren't flagrant prosecutorial misconduct. That's pretty much the issues that were addressed. If there are no further questions, I'll rest on my brief.
Thank you, Mr. Newman.
Your Honors, I see 2 key flaws to the arguments that were just presented. The idea that because he's in a car, that it's reckless to drive in this fashion completely dissolves the statute, RCW 4661.502. That differentiates between different ways that you can operate a car and cause vehicular homicide. They all set a high bar, whether you're intoxicated in drugs or with drugs, whether you set disregard for safety of others. But reckless is by far and above the others. Death can occur in many ways in a car: accidental, non-accidental, intentional, negligent, reckless. Reckless is a high bar akin to firing a gun to a crowd with knowledge that it's going to, harm somebody. There's no evidence Mr. Laine had that sort of knowledge that can be inferred from the record. And then what I heard about the prosecutor.
Can I ask you?
Yes.
So, if the evidence is that your client is committing numerous lane violations, both over the fog line and into the other lane, over a sustained period of time, you are asking or suggesting that the only proper inference from that is that that is due to distraction and not due to purposeful lane violations. So you're asking for us to take the evidence in the light that is not the most favorable to the state. If you're asking us to simply assume that each of those lane violations, particularly the ones that are going entirely into the oncoming lane of traffic, are due to distraction, where is the evidence in the record that you can point us to that would point to what the distracting factor was that would support that, as opposed to your client intentionally driving in this manner?
I would point to the lack of any testimony or evidence that he was acting purposeful. I'd point to his own testimony that he was looking out his peripheral vision, trying to avoid obstacles. He had his own testimony that he had mental stressors going on in his life and was anxious. And there's just never been
So
any.
he was driving this way to avoid obstacles, such as what?
He talked about at one point he thought he saw something like an animal or something dart out of the side of the.
Over the course of 10 to 15 minutes.
There's
this
cross
same
streets
animal?
that could have accounted for one of those deviations. Another deviation could have been for other reasons, Your Honor.
So again, you're asking us to take the evidence in the light most favorable to your client?
No, I'm not. No, I concede the standard of review, Your Honor, but I don't think that it's proper to assume purposeful. He's entitled to a trial on the evidence, and there was no
So I'm saying
evidence.
the jury could have inferred that, not that I'm saying that. I'm saying that you are saying the jury was sort of required to infer distraction, and I'm asking you, couldn't the jury have also inferred purposeful conduct?
I don't think the record supports that, Your Honor, is what I would say. But
What do we do with the evidence from Miss Williams, who was so alarmed that she honked her horn and flashed her lights to no avail?
Right.
What do we do with that evidence?
we have case law that I cite in my brief, like State v. Plummer. It's an out-of-state case, but they talk about how there was no testimony that his windows were down, that he would have heard that sort of thing, or perceived it to be related to himself. We ask the court to reverse, Your Honor. Thank you.
Thank you, Mr. Orheim. Thank you, Mr.
Following these arguments, the court found no valid error and affirmed Mr. Laine's conviction. What is a fair sentence for reckless driving causing death? Let me know what you think in the comments below. If you like this video, let us know. Until next time.